Hello, it's Phillip Taylor speaking from Richmond, Green Chambers in London. Now this morning I'm talking about an interesting book that's come to us from Sweet Maxwell. This is the 5th edition of a book called the EU Merger Regulation. Substantive Issues is the subtitle for it. It's a complicated area, but I think it's very well explained by Alistair, Lindsay and Alison Berridge. I'm delighted to be able to review this work. Elizabeth and I talked about the book, and Elizabeth has produced most of this particular review, but I've had some input to it. Now, our title for the book review is The Legal and Economic Ramifications and Hazards of the Urge to Merge, Examined in the European Context. Now, that's an interesting point because obviously we're right at the heart at the moment of Britain's decision to leave the European Union. So therefore, what I'm saying is relevant at the moment. For how long, I have no idea. Let's have a look at the book anyway. It's very much the house style for Sweet Maxwell, THOMSON, REUTERS. It's a heavy book. It's a hardback in blue. There's the heading there, and then there's some spine. You can see on the spine. There's nothing on the back. Opening the book up at the back of the book has, again, a very useful index, which you can see there. Just have a look at that index, and you'll notice from the way the index is structured that it's actually very much part of it's the legal taxonomy of Sweet Maxwell, which means that you have paragraph numbering, and you also have the standard names and the allocations for titles for particular areas of law, which links to all of the Sweet Maxwell publications. That's partly what it means, so that will at least help you with what you're looking for. And you can see at the back of the book you've got paragraph numbering and you've got footnotes. You've got a huge amount of detail in 700 odd pages. The front of the book, there's a nice divider. It's actually in red there, you can see. Now that's to find things if you need to look at them quite quickly. Now there is the actual main front page, and then after that you've got some detail there, and then there's a dedication which I will show you there. You can just read that dedication from the authors, and after that you've got acknowledgements, and then a preface. Now the preface is quite important because this is not in fact the easiest of books to follow. There's quite a lot of case law as well, so it's useful to just read the beginning of it to get some idea. The structure of the contents is relatively straightforward. They link in, I've found, very nicely with the back of the book, so you should be able to find things quite quickly. The contents section is detailed and it runs on a bit. You will see that the total number of pages, the total number rather of chapters is 12 main chapters. In fact, that's for that part, but what you've actually got at the back is a series of additional paragraphs right up to paragraph 20, but in fact in the contents itself you've got, what you do have are the specific chapter headings, so don't get confused between the two because of the numbers within it and the actual main paragraph numbering, because the paragraph numbering as I say goes up to 20, and that of course remedies as usual is at the back. So that's basically how to find things quickly. As I say, it's not the easiest subject to follow, so be careful with all the subheadings which are inside each of the main chapters. Then you've got the tables of EU treaties, secondary legislation, etc., all of that information there. Some guidelines on a country by country basis as well, which is quite useful. Then you've got decisions of the CJEU, as we now call it, which we're still members of at the moment. Then you've got, this is European Commission merger decisions. Again, an important area at the moment. How long, I don't know, but obviously that's going to be around for some time, notwithstanding anything that happens with Brexit and what sort of information we do salvage once we've left. Then you get to Chapter 1, which is the economic justification for merger control. And then as you see, you've got paragraph numbering there. So chapter 1, then the number is 1, and so on. But be careful with the individual numbers within the chapter itself. Then you've got footnotes. and as I say, it goes all the way up to 20 on remedies at the back. Altogether a very good book. Whether you're pro or anti the EU, this is a book that one needs to be aware of, because whatever happens, we are going to be part of the European Union for some time to come. And I think therefore we do need to know what the issues are concerning merger regulations. Now, what do we say about the book? Well, it's for corporate lawyers, especially those embroiled in advising on competitive and or anti-competitive practices. The familiar term usually used in transatlantic parlance is monopolies and mergers, or M&A. Now, as I say, you don't really see those words mentioned here, but because we are talking really about competitive and or anti-competitive practices. And as the title indicates, this book focuses on the latter, specifically in the European Union context. Now, it's recently been published by Sweet Maxwell, which are part of THOMSON REUTERS, and it's a long-established title now, which has come into its 5th edition, and it certainly, in our view, attests to its reliability and authority, that it has had that sort of durability. Scholarly, thorough, technical and precise, and what the two authors have done, as Alistair, Lindsay and Alison Berridge, is elucidate and examine in detail the complexities of its broad-based subject matter, which is what this is. It's important, of course, as well, notwithstanding whatever side of the membership of the EU fence you're on. They all recognise the importance of this at the moment, and obviously for any future that Britain has outside the EU. And a key consideration throughout is what's called market power, which can be defined in a number of ways, but whatever the definition, mergers have profound effects on market power, inevitably either undermining it or enhancing it. And in the view of the authors, market power manifests itself as something of a duality, which may be categorised basically in two ways. That is, original market power and exclusionary market power. See, we're getting into the sort of legal areas very quickly here, but you see we've got basically two categorizations, or two categories. Now, original market power is achieved when a company alone or with other suppliers is able either to increase price or quality or variety or possibly innovation relative to the prevailing competitive level, usually for a prolonged, in other words, a long period of time. Now, exclusionary market power does much the same thing, except that one or more of the company's competitors may be excluded or marginalised, giving the company what anyone probably else would call unfair competitive advantage. And anybody who, as I did when I did my bar school studies, and I did this module, the international trade module, was very well aware even then of this possibility of having this unfair competitive advantage. And of course the problem we've had over the centuries in the English courts is the courts have been very reluctant to interfere with this sort of area, but we have had quite a change in the 40 odd years that we've been involved with the European Union, or common market as it was of course originally known. Now, much of the book is, in the words of the authors, quote, devoted to determining whether a merger will create or enhance original or exclusionary market power, with a view to explaining the trade-off between market power and efficiency. And obviously one can see clearly that if you're wanting to make money, you've got to have that balance, the trade-off between the two, market power and efficiency. Now, the objectives here centre on analysing the treatment of substantive issues under the European Union merger regulations. So we're getting to the Commission very quickly, and hence all the stuff from the Commission in terms of decision making, and of course the objectives which thereupon underlie it all. Again, this is all coming from the EU merger regulation. And the goals of antitrust policy, say the authors, must be made clear if said policy is to be applied coherently. Well, you can see the sense of that. The comment was also made that as the law and practice of EU merger control has continued to evolve, this latest edition, and it's the 5th edition now for 2017, they have most, obviously the previous edition was published, and obviously it's examining this particular area extensively and in detail and trying to keep us as up to date as possible. Excuse me, which is exactly what we're expecting. Let me conclude by making these comments. The book excels as a source of reference for further research, as is evident from the massive amount of footnoting alone. Also note there are 4 tables that EU lawyers and the UK lawyers too, either pre or post Brexit, will doubtless find indispensable, and here's the list. These are the following: treaties, secondary legislation and notices, guidelines, decisions of the CJEU, and the EC merger decisions themselves. That's the European Commission merger decisions. Now, I said all of that because this book came out in 2017. We're going to leave the EU in 2019 with a transition period up to about 2021. So I would think that looking at the timescale, the next book to come out will certainly be post-Brexit. But it depends very much on what happens in the next couple of years. And as you may infer, the book covers a vast area of scholarly inquiry where law and economics are inextricably intertwined. Now, it offers impressive coverage of a formidably wide range of issues pertaining to mergers within the EU, and deserves, we think, pride of place in every well-stocked law library, especially if you have, as many do, a certain EU jurisdiction for practice at the moment. I don't know what the future holds, but certainly this book is an important one, and that's one of the reasons why Sweet Maxwell have produced it. There it is again, and there's this one. Let me open it in the middle to give you an idea of the flavour of it. This is we are now here at coordinated effects introduction. You see, one of the problems, actually, I do mention this, you see a huge amount of footnoting there, so you've got very little in the body copy on the first page of chapter 8, and you can see again it runs through. So you do have that little bit of additional, if I can say, a bit of a problem, because you've actually got a lot of the footnoting, which shouldn't detract, of course, from the basic body copy, the main text of the work, but you do get that because a lot of it is trying to explain what is actually happening at the moment and some of the changes that are taking place. You've got market share data, for instance. Here's a chapter here. This is in chapter 4. It's looking at control shares, total shares, and so forth. And again, you can see a lot of footnoting again. I wouldn't say that's a criticism, but it's something you should bear in mind when you're reading the book. I'd like to thank both Alistair and Alison very much indeed for producing this work, and also to Sweet and Maxwell, Thomson REUTERS, for continuing to publish these books. They're very important books, and in fact this particular work, obviously this is 2017, I'm not quite sure when the first book came out, but this is obviously, the book itself has been around for some years now, and it's one of those books which I do think just adds that extra gloss to our knowledge about how to look and view these matters, especially in an era of such massive change which is now upon us. So thank you very much to everybody for giving us that extra support. We do appreciate it. Thank you. Bye-bye.